Four men who are allegedly connected to the killing of rapper eNCA and his friend Tebello Tibz Motsoane are expected to appear at the Durban Magistrate Court this morning. However, their legal representative, that's Advocate Annelien van der Heever, says their rights have been violated as they were held without charge for more than 48 hours. The men were arrested on Sunday in Cape Town, and according to reports, police never revealed to them why they were being detained. Let's find out what the law says about these developments with legal expert Mpumelelo Zikalala. Mr. Zikalala, good morning, and thank you very much for your time. So the arrest of these four men in relation to eNCA's death could possibly now, just looking at what's happening, turn into a trial within a trial, because their lawyers already speaking of violation of their Section 35 rights in relation to the amount of hours that they've been detained without appearing in court. Can you just unpack Section 35 for us? What does it require?
Section 35 is clear. It says that you have a right to freedom of movement. So if that right is going to be contained or be deprived of, it must be done within the confines of the law. Firstly, if you have been detained, make sure that you are appearing in court within the next 48 hours. Now, that's the responsibility of the law enforcement agency. Now, it's clear. Once you've been detained, the Criminal Procedure Act then takes place, and then you are either continue to be detained after, though you've been told why you're in court or why you're going to stay behind bars, and you then allowed to apply for bail as per Section 6 of the Criminal Procedure Act. If those particular processes have not taken place, then definitely your rights have been violated. You can sue the state for that, but it does not mean that the main charge in which you are charged for will then fall away because there have been these type of transgressions that have taken place. But from what you have stated a few minutes ago, it does seem as if the state may have bundled a bit in terms of the arrest of these individuals, and they may be forced to release them so that they don't find themselves in much more hot water than actually what they're in now.
In what instance, though, would be police allowed or freed from non-compliance in this instance?
There's none, unless it's due to circumstances which is beyond their control. One, if you want to extend the interpretation, you can say, let's look at 48 court hours. However, the act of the Constitution is very clear. If at the end of the 48 hours nothing has taken place, take them to court so that they go and appear. All that is required is for an individual to know what is happening with it at that particular point in their life, be in front of a presiding officer who is going to tell them that it is alleged that you have committed these particular crimes, and the police still in investigation or time to investigate your matter. You have a right to seek legal rep. Your legal rep is then given access to you. You are then able to apply for bail, which is an urgent application in its nature. So what it tries to guard against is for people to be detained for long periods of time, without knowing what they've been detained for, without having access to legal representation, which is a right that is construed or which is lamented within our Constitution.
I'm glad, I want to take you back to your first point, and I'm glad that you touched on it, that non-compliance on the part of the state does in no way mean that you are now freed from the charges of the initial crime, because some people, there's then that debate that if procedures are not followed to the T, then in most instances you'd be somebody that would be let off scot-free. In this instance, you're saying they would separate the two, deal with the non-compliance, you sue the state, but if you must account for perhaps the murder of eNCA, you will still have to account.
Definitely. Let's separate into three parts. The arrest part and the bringing to court in which the bail application would apply simply means that we need to get your attention. We need to get you into a forum in which your matter will then be able to adjudicate it. Evidence would be laid against you, would have an opportunity to rebut that evidence, and then a decision will then take place. The second part is when the actual trial actually starts, and the third part is due to your sentencing if you are found guilty, and the serving of that correctional time. So the mere fact that the manner in which we were arrested has been bundled does not necessarily mean that on the merits of the case, on technicalities, you're going to be let free. The only time in which it would have merits in terms of whether you're going to stay in jail or not, be found guilty or not, is when the collection of the evidence was done in an unlawful manner. The type of evidence that has been collected by the state cannot be used by the state or allowed by our courts as evidence that should be considered. If that's the basis, that means that you win your case based on the lack of evidence and not on anything else. So at this stage, the state may have bundled, yes, I do agree, but does not necessarily mean that on the merits of the matter, they found themselves wanting. They still can be successful if they have evidence which will be able to prove that the individuals which they have been caught are the ones that committed the unlawful act, and they can be found guilty beyond any reasonable doubt.
Now, many South Africans have been hoping for a breakthrough in this case and are welcoming the arrest, but there are fears in some quarters that the pressure to effect arrest could lead to many mistakes. What could be the consequences for the state if it turns out that, in fact, this was a wrongful arrest?
I always say that sometimes the states would arrest for the purpose of investigating, and that would lead to these numerous delays in which a person would be arrested the year before, and actually the trial will start 2 or 3 years later. Now, that has something to do, or will have a very serious impact on the quality and the quantity of the evidence that can be used. Let's take a step back. The state, when it goes to court, it has to prove beyond reasonable doubt that the people that are in the accused box are indeed the individuals or the perpetrator that committed the unlawful act. If you cannot do that due to people dying, due to documentary evidence being lost, due to certain pieces or sequence of events or the chain of evidence being broken, due to either people dying or maybe that evidence going missing, you are going to have a very difficult time being able to prove beyond reasonable doubt that these individuals that are in the witness box are indeed the ones that committed that particular act. That includes, by the way, how the evidence was then collected and then stored and then actually presented in court. So if you are going to be quick on the arresting part without securing the evidence in which you need in order to prove that the people that you have arrested are indeed the ones that are the perpetrators, that is where you are going to have a problem. And that's where you're going to find instances in which you arrest individuals, take them to court, they are found not guilty, and there's no closure even for the family because they have no one that they can be able to hold accountable. Or the individuals may be there, but due to technicalities, they have to be let free because our law is very clear as to how to hold someone accountable, how to exercise your part as a presiding officer to arrive at a guilty verdict.
Mr. Zikalala, I have a feeling that tomorrow we'll be back meeting around this time to analyze the proceedings from today. Thank you very much for your time as always. That's legal expert Mpumelelo Zikalala.